Thanks. Please be seated. We are on the record in oral argument in CV21 0354 UMB Bank versus Parkview et al. We live stream and record the proceedings, so please state your name and the name of the party you're representing when you begin. According to our protocol, everyone's going to go to the center to give their argument. You have 20 minutes per side. We don't require you to use all that time, but we do require you keep track of it, including any time you'd like to reserve. Please keep in mind we've read the briefing, we've studied the record, and we have conferenced this case before oral argument. And with that, counsel, you may proceed.
Good morning, Your Honors. May it please the Court, Bradley Burns for appellants, Parkview School and the Charter Management Group. I'm going to go straight into the central issue of this appeal. It's why Arizona's Notice of Claim statute applies to UMB and the claims it actually brought in this case. There are two independent reasons why the Notice of Claim statute applies to the posture of this case. I don't want to lose sight of either of them, so I'll come back to the second one in a minute. The first one is Arpaio. It's uncontested that Parkview School is a charter school. It's a public school entitled to the protections of the Notice of Claim law. So in a general sense, the Notice of Claim law protects Parkview School. The question we turn to is whether or not the claims actually brought by UMB, a creditor of the school or a trustee for creditors of the school, implicate the Notice of Claim law. Now, the statute itself, it only speaks in terms of claims. It doesn't subdivide claims into different types. But there's judicial exception that has been made. When someone seeks merely declaratory or merely injunctive relief, the Notice of Claim law doesn't apply. And that makes sense because, for example, if I were trying to restrain a government actor of some kind from, unlawfully beating me with a stick or something like that, you wouldn't submit a demand and wait 60 days for it and ask for money for it. You're asking, stop this conduct right now. And that's why that exception was made. What's happening here, and the reason we're appellant rather than appellee, is because the trial court misapplied by ignoring this court's teachings in Arpaio.
Well, the claim here, the central claim at issue is for appointment of a receiver, yes?
That's what it's denominated, but that's not what it does.
Well, let's start with how it's denominated. How are you going to comply, or how would one comply with Deer Valley when the claim is for appointment of a receiver?
Both in a general sense and in the facts here, one would send a notice of claim that says, you owe me a debt, and I'm seeking a receiver as a result of it. And I'm asking the court to have that receiver pay me over $9.1 million. I will settle the claim for $9.1 million. You comply with it just like any other case where you're seeking the payment of money.
Well, that's if your claim is for the full amount of an accelerated debt. But that's not the case here. Here, the idea, I believe, is that the claim is about appointment of a receiver to manage ongoing prospective payments under an arrangement that does not, thanks to Minnesota, include the forbearance agreement that you believe is appropriate. Right? But there is no, yes, one could ask for the moon and say, give me $100 million and I don't really care so much about this receiver, but that's not practical, it's not realistic, and we know that it's not going to happen. So the receiver, I believe, is more akin to an equitable claim designed to take over management, not to disperse funds directly.
In a general academic sense, Your Honor, I don't know if I agree or disagree with you on the general application of a receiver, but that's not what this complaint is.
Well, but in this complaint, didn't they allege that Parkview not only was not paying, but was making loans to other schools, was dissipating assets, was selling borrower assets, failed to meet the charter board requirements, so it was threatening their charter? For them to have ongoing payments into the future, they needed to stop and have a receiver appointed so that these assets wouldn't be dissipated anymore. How would you do that, affecting the money of Parkview without violating a notice of claim statute saying you have to ask for a sum certain if you want to come in and do that?
If you want to bring a claim against a public body, like Parkview School, you have to file a notice of claim. You're talking about a process outside of the statute where someone can go in and seize public funds without ever filing a notice of claim. But that's not what the complaint does. Moving back to Judge Swan's concern, that is UMB's characterization after the fact of the complaint. That's not what it does. It is not merely the appointment of a receiver. First of all, at paragraph 73, it alleges that the amount due and owing in this verified complaint is over $9.1 million.
Yes, but in the prayer for relief, does it ask that that amount be paid?
It asks at paragraph 88, subsection 3, asks for instructions that all monies be paid to the receiver, by the receiver, to UMB for all amounts that are due. So in paragraph 73, it defines what is due and owing as $9.1 million. And then it asks for a payment of those at paragraph 88, subsection 3. It also asks at verified complaint paragraph 93 that the defendants turn over to the receiver and all monies held or received by the school and grant a constructive trust over such monies in favor of UMB.
So you're saying this is just an action to collect a debt and the receiver is a red herring? We don't need a receiver at all.
I wish I could characterize it that way, but I'll stand in UMB's shoes. No, they wanted to take all of the assets of the school, seize them all, liquidate everything, all the real estate, all the property, all the collateral, and then take all of it. So the receiver is an important step in that because they want to liquidate everything to get cash.
But is the fact that Judge Warner didn't grant everything that they wanted and restricted the acts that the receiver could engage in as part of the receivership solve some of the problems that you're saying?
So that's such an interesting question. That is an issue of first impression for this court. What is the measurement point? The measurement point is the complaint. We could have won everything. You just heard a notice of claim case. That could have gone to trial. And the Board of Regents could have won everything in that case. The notice of claim would still require dismissal at the beginning. So the measurement bar is the claim that is made. So the fact that Judge Warner has given us some relief after the fact doesn't change that the claim is barred in the first instance. So it's the measurement is the verified complaint that's filed and what it asks for.
So just to make sure we're on the same page, if this were a purely skinnier complaint that just asked for appointment of a receiver, you would agree that a notice of claim is not required?
The answer is yes, Your Honor.
Okay. But because it's adorned with these allegations that there are significant debts owing, and the court is forewarned that that the repayment of those monies will be one of the pieces of relief sought at the end of the day, that's what changes this to a notice of claim case for you.
That's what conclusively establishes it. And, Your Honor, this isn't hypothetical. The proposed orders filed in the trial court recently, UMB asks for all the leftover cash to be handed over to it. Now, I don't know what Judge Warner is going to rule. We understand he has ruled, but the scan hasn't gotten in yet. But the point is that the measurement bar is the complaint. So it is possible, Your Honor, to make a receivership that is definitely something more like a declaratory or an injunctive case. But that's not what UMB did here. This is all about a debt. This is all about liquidating assets to pay a debt that's due and owing.
Okay.
That is what puts us squarely within our pile. A receivership without financial impacts is how you get a receivership, perhaps, outside of 821.01. When it's financial, when it's predicated on a debt, when paragraph 73 says $9.1 million is due and owing, and that alleged fact is used as the cudgel to obtain the relief, UMB is stuck with that. They made that strategic decision. There's about 75 ways you could do this. UMB decided that it was going to pursue $9.1 million in payment in a receivership action by liquidating everything. And under Adams v. Baer, they are stuck with it. It is the truth. So we can talk about, there's a lot of counsel denying acceleration in appellate briefs, but there's no fact that demonstrates that. There's the verified complaint. In paragraph 73, I just have to point out, UMB has just run from it. We've raised it at every level. It's never been substantially addressed. The legal effect of saying $9.1 million is due and owing. That is the allegation of the complaint, and that is the fact that we are here with.
How are we to take anything from the agreement that they made in section 8.02b as to what a receivership meant and the factors upon which they could ask for a receivership and what the duties of a receiver would be under their contract, under the indenture?
it's a contract right? So there's a receiver's allowed to do what I'll call certain things. There's a list, right?
Right.
We dispute some of the scope of that, but that's not important. That's a contract right. It's a contract right to use a receiver to take money and be paid, right? That's what it does. That doesn't change a notice of claim requirement. So it's like any other contract. It's a contract claim, a notice of claim needed to be filed. The reason that the allegation in paragraph 73 is so important is because what this court did in Arpaio, there was a similar allegation in Arpaio. There was this argument of waiver, and I'll get to waiver in a few minutes, but there was allegations of waiver by the public body in Arpaio, and Arpaio said, let's just take the latest possible date of accrual, okay? Latest possible date of accrual was the filing of the complaint, and that's what the latest possible date of accrual of the entire debt is here. And that fact does matter, is when they said, UMB said $9.1 million is due and owing. That's the latest possible date of accrual. The question is, did UMB file a notice of claim within 180 days of that date? Now, we would contend it accrued somewhat earlier. There's the Minnesota action. I don't need to go over it at length, I'm sure, but the Minnesota action sought a direction from the court to pursue all these remedies, including acceleration. That would accrue it too. But the latest possible date is the filing of the complaint with paragraph 73 within it. There's no notice of claim within 180 days of that. UMB supplied the only notice of claim they ever filed, and it was in December 2021, which is farther in time than April 5, 2021, farther than 180 days. So this court is in the same position in Arpaio. You can just take the latest possible date of accrual. I said that accrual matters. Accrual does matter here. Part of the trial court's order is predicated on, well, there is a notice of claim problem, so some of the past debts may have a problem, but the things ongoing don't. The fact that the entire debt is now barred by this notice of claim law. It's the entire debt for failure to serve a notice of claim. That's something that we need the court's guidance on to guide the trial court.
So it's your contention that the bondholders are just out of luck because of the notice of claim?
They're out of luck as against Parkview School because their trustee did not serve a notice of claim. What remedies they might have, I don't know.
So what are the restrictions on what Parkview School can do with all these millions of dollars at this point?
I'll start with that's not in the record, but it's an Arizona nonprofit. It has a charter. We believe we'll keep the charter when there is debt relief. The troubles that the school has had at the charter board are due to financial difficulties primarily. So what it does would be in accordance with its nonprofit and its charter.
I mean, due to financial difficulties is a pretty abstract contention for a school that takes a whole bunch of millions of dollars of bondholders' funds and then claims that because of a simple notice of claim that would have demanded a sum certain in settlement that it never could have paid because it had dissipated the money, now it's free and clear. I mean, doesn't that seem like a bit of a bootstrapping argument?
It strikes me as very harsh, but not bootstrapping. Okay. Most of the money went into the purchase of real estate. So the dissipation stuff, Your Honors, these are the allegations of the complaint. So I'm talking about a motion to dismiss, so I'm stuck with them. There was an evidentiary hearing afterwards. Those were overblown pretexts that had already been resolved. The sort of dissipation of money stuff, those were frankly not big deals and not huge amounts of money anyway. They were minor disputes that were mostly resolved. But when you're talking about, yes, you have this enormous debt, and it was a valid debt at one point, and now you're saying, yes, this public body is free of that debt because someone didn't send a piece of paper in. That is what notice of claim does.
So if I'm a bondholder, my rights to have that bond repaid are now derivative of the procedural maneuverings of a trustee.
That is correct. Like any other creditor, these are sophisticated investors that acknowledged in the bond documents that these were high-risk investments. And they put their faith in a certain trustee who did not do what that certain trustee needed to do. Harsh, to be sure, but that is what notice of claim law is. And as far as remedies for a bondholder, it's not against Parkview. I want to take a step back to finish the section. Notice of claim law does apply. If you go and take Parkview's conception of I get to slap a receivership label but get to ask for payment, you're talking about a world, it's Arpaio but farther than Arpaio. It would be as if the sheriff had said, replace the Maricopa County Board of Supervisors with my receiver, sell everything the county owns, pay me the $24 million and hold the rest in a trust fund for my benefit. It's farther than Arpaio, what the nature of this claim is. It's a complete financial takeover, liquidation, and pay to self. the notice of claim law must apply in these circumstances.
So what if the contours of, let's say that we agree with you in part, okay? Because to be sure, sums of money that are past due and owing would, I don't see any way out of them being subject to the notice of claim requirement. But if the purpose of the receiver is administration to make sure that prospectively monies are managed in a way that best protects the bondholders, that's it. Prospective, no direct payments. Do we have a notice of claim problem there?
On this complaint, yes.
Why is that?
They did not file a complaint that just asked for that. And then there's another problem, and I said I didn't want to get away from it, and I did. There's a second problem, which is that this debt is barred. There's no standing to ask for a receiver. So even if this were a procedural complaint that could be filed, okay, it's a receivership label, we're just going to accept the face value of that. That lawsuit can be filed. Why does UMB get a receiver? Well, it's because a debt is owed. But a debt is not owed because it is barred by the passage of time. So there's no reason to give UMB a receiver. A court, I don't have a right over a receivership over Walmart. They don't owe me anything. And UMB used to be owed something as trustee, but they're not any longer by the passage of time.
So in your view, the Minnesota judgment is completely irrelevant at this point. You've got it all sewn up with notice of claim, so it doesn't really matter what happened in Minnesota. Is that right? It's
secondary. I mean, it's secondary. And also in a practical sense, the school's taken a lot of, I call it damage over the last year. We've been in this case for a year. Whether or not a forbearance agreement now would actually practically do anything, it's questionable. Now, of course, we do press those issues still, but the central issue in this case is the operation of the notice of claim. And the ground has changed in the time since the appeal got initiated. The latest possible accrual was April 5, 2021. There was no notice of claim timely. That wasn't necessarily true on April 5, 2021. So the notice of claim case has gotten significantly stronger. UMB cannot escape the allegation it made. It cannot escape the fact that it said $9.1 million is due and owing. No one can undo that. It's a verified complaint and they are bound to it.
No one can undo what they said, but you're not bound by the terms of your complaint. We plead in the alternative all the time. Some claims succeed, some claims fail. It may very well be that many of their claims fail, but the mere fact that they mentioned that there was money owing, which was really no secret anyway, doesn't seem to me to be definitional for the entire scope of the litigation. It seems that the more important thing is what relief the court affords.
I understand Your Honor's point. With respect, I do disagree. You
never plead in the alternative? You should try it.
There is no alternative pleading here. So if they had said $9.1 million is due and owing, and in the alternative $1.5 million is due and owing, okay. This is a verified complaint with facts alleged and signed by a client. They've never even attempted to amend. They've never even attempted to add alternative allegations. We're sitting here. They wish they hadn't said that, so they're trying to undo it on appeal without actually asking to amend. Sort of regret of doing that doesn't change the fact that making that allegation accelerates the debt at the latest. That's the legal effect of doing that. They pursued payment of all sums due from the trial court, and they said all sums due was $9.1 million, which at the time was all of it.
Well, making that allegation may not be helpful because they may lose that claim, right? I mean, if those claims may be time barred or barred by a claim presentation deadline, but they don't necessarily fail to lock in other forms of relief.
Your Honor makes the point that there can be multiple forms of relief, and there can be amendment, and there can be alternative pleading. I agree. Mm-hmm. But the legal effect of pursuing payment of $9.1 million, which it was alleged to be due and owing, is that that's the latest date the debt could accelerate and become due at that moment. That is the latest date. And I understand there's some flexibility in pleading, but not on a verified complaint and not when the defense in the reverse is, no, it's an installment debt, it hadn't accrued yet. But you pursued the entire thing. It does accrue at that point. With that, I have 1:10 left, so I will hold the rest for rebuttal.
Sure. Okay, thank you.
Good morning, Your Honors. My name is Andrew Federhar, and along with Jessica Gale from Spencer Fane, we're here representing UMB. Your Honor, when you look at the list of issues that were presented to you as being brought before this court on this appeal, and then listen to the argument of Parkview just moments ago, you'll notice a stark difference. In the notice of appeal before you, Parkview never contested that the receivership was wrongfully granted, that there was an abuse of discretion in granting that receivership, that there were insufficient facts to establish that receivership. None of that was alleged in the notice of appeal. And you know that a receivership is a harsh, and as this court and the Supreme Court has described it, extreme remedy of taking away property only when there is overwhelming evidence of misuse. That was the finding of the trial court when it established the receivership. And that establishment is not an issue on appeal before this court. So when counsel tells you, and some of the words were remarkable, that these were minor things, that the complaints are overblown, there's no issue before you about that. The trial court made a finding that a receivership was justified, and you will look in vain to see that finding challenged in this appeal. So now, having established and waived the issue that the receivership was wrongly granted, they come before you and try to minimize the effect of that. So the first thing that we need to talk about today is that indeed the receivership was established because the evidence was overwhelming. Counsel also mentioned in passing that Judge Warner had signed an order last Friday, and we received it just yesterday. Judge Warner dismissed the receivership. Now, I don't have the full order yet. Our office tried to get it from Judge Warner's office, but was unable to get a copy of the signed order. We do have the minute entry, and I'm happy to leave a copy of it with your clerk today. We just received it yesterday, as did counsel for Parkview. But the receivership has been dismissed. And I'm not sure whether that moots this action or not. Frankly, I haven't had enough time to think. I think slowly, so I'm not sure exactly what that means. And this court still has discretion to decide issues that might evade appeal or appellate review, because receiverships can sometimes be pretty quick actions that might otherwise escape appellate review, yet be subject to repetition. But be that as it may, the receivership is no more. We understand, but I can't show you an order, that there'll be a wind-up time for the receivership of a couple of months.
It's a little risky to ask this, but can you give us some idea of what led to the dismissal of the receivership? What thinking?
I can't, Your Honor. I would never speak for what Judge Warner was thinking.
So the minute entry doesn't contain reasoning?
No, sir. And again, Your Honor, I'm happy to leave a copy with your clerks, and we'll do so.
No,
But it did not say because.
Are you planning to appeal that ruling?
No, we sought the ruling. The receiver reported that the schools were not able to show that they were an ongoing concern. It's not just the debt. They couldn't attract enough students. The schools failed because they couldn't attract and keep students. And aside from the self-dealing, where they were making transfers they were not supposed to, aside from the fact that they used the money for Parkview schools, for other charter schools that they were using. I mean, these are not minor violations that stripped the assets of the charter school for this purpose.
No, I understand that, but if the receivership is gone, do you agree that the deadlines under the Notice of Claim statute preclude recovery of some of the past due amounts?
No, I don't, Your Honor.
Why is that?
Because the issue is, first of all, not ripe. The question of whether the receivership is appropriate in and of itself, and I think I'm pretty strong grounds when I say equitable remedies are not subject to the Notice of Claim statute. So,
in general, I would agree with you.
Okay, so
but that leaves the point that the complaint, as it's drafted, uses a receiver to accomplish the repayment of debt, and that some of those amounts appear to be barred by limitations or...
Except, Your Honor, the forbearance agreements.
I'm sorry?
Except for the forbearance agreements. And in the forbearance agreements beginning in 2017, Parkview waived all defenses that were otherwise available to it, and we cited those provisions at length. So, no, I don't agree.
Okay.
Now, a question, it's legitimate to ask, can a governmental entity waive its rights? And I think the answer is yes. This is a contract. This is something where the parties are clearly sophisticated and enter into it an arm's length relationship. And Parkview waived those rights repeatedly, not just once, but repeatedly. So I think, yes, I can say here that we
And
can
these
go
are
back and get
forbearance agreements that you believe are still in effect,
Well, so,
as opposed to the agreement that the Minnesota court dealt with?
well, the Minnesota court was simply asked to give direction. Do we have to listen to this petition that Parkview circulated and received votes from 41 or 42% of the bondholders, but not 50% plus? Do we have to listen to their direction? Or can we pursue the remedies that are available to us under all of the loan documents? And the court said, no, you're not bound by that ballot. It didn't have 50% plus one. And yes, you can pursue whatever remedies you choose to under the loan documents. But the key factor here, Your Honor, is that the forbearance agreement says in Section 6, quote, the borrower, Parkview.
Are they the same in both years?
Yes, ma'am.
Okay.
Yes, they are, Your Honor. The borrower further acknowledges, agrees, and affirms that the provisions of this Section 6, and Section 6, let's go back to the start of Section 6. Sorry, my fingers aren't as nimble as they used to be, is a release of claims and waiver of defenses, wherein Parkview waived all defenses of any kind resulting from or related to any act or omission by any released party, that's us, with respect to or any acts or omissions arising in connection with the covered defaults. In other words, they waived all defenses to their existing defaults, which I think includes the notice of claim statute, Your Honor. So let me read this again. The borrower further acknowledges, agrees, and affirms that the provisions of this Section 6 shall survive the expiration of the forbearance period. This is a contract in 2017. Contracts have 6-year statutes of limitations. I don't think we've waived any rights under our various documents, Your Honor, for past due payments. Now, let's get to the meat of this, the question of whether the form that UMB pursued somehow prejudices it or somehow denies it a right to recover on behalf of its bondholders the money that's due and owing here. And there's been a lot said about Arpaio, and unfortunately, I don't think it's an accurate recitation of Arpaio. Let's go to paragraph 11 of Arpaio, and I've been in front of this court enough to know not to read you your own cases, but I apologize for doing so right now. In paragraph 11, the court says, quote, as it relates to any claim against the state, the sheriff's amended complaint merely sought declaratory relief. We agree with the sheriff that one who seeks declaratory relief need not comply with ARS section the claim statute, and it cites a case. However, even assuming a favorable declaration by this court, to the extent the sheriff then would seek recovery of some or all of the $24 million from the state, such a claim would indeed constitute the type of claim requiring compliance with the notice of claim statute. In December of last year, we sent Parkview a notice of claim. And in that notice of claim, for the first time, we followed the procedure set forth in the indenture agreement and the loan documents about how to accelerate. Acceleration doesn't just come by saying you owe me $9 million and it's due and owing right now. That's not how you accelerate under the loan documents. You accelerate by giving notice to specific parties and saying that the amount is immediately due and owing. And that language, we've challenged Parkview to show you that language and that notice in our response brief. And they didn't do it in their reply because it's not in the record. It never happened until we sent out the notice of claim and accelerated for the first time pursuant to the terms of the loan agreement. So at no time prior to December of 2021 did UMB accelerate according to the terms of the loan agreement. Then we did, and we sent a notice of claim. So to the extent that we were seeking past due monies, even though we thought there was a waiver, belt and suspenders. We did it both ways, as Your Honor was asking now and earlier today in another case, alternative pleading. We covered our bases by proceeding under both particular ways of proceeding. But to be clear, acceleration is not just, you owe me all the money. Acceleration required notice to various parties in specific language that was not used until December of 2021. So let's go on and take a look at the remaining issues that we have here. First of all, if they're going to claim that our notice of claim was somehow deficient, the Marbury Ranch case is a very, very useful case, because in that case there had been years of claims between the ranch owners and the state, years. And the Mayberry Ranch owners said that's sufficient for the notice to claim statute. And this court agreed. And that was never changed. That was never reversed on appeal. So what's the phrase I'm looking for? The course of conduct between the parties over multiple years can in fact satisfy the notice of claim. And so the forbearance agreement in 2017, how can it be anything other than the settlement of claims? We forbore, I'm not sure what the proper grammar is, we gave up our right at that time to foreclose on the property, to appoint a receiver, to do all those other sorts of things. And all of that is set forth in the forbearance agreements that are in the record before this court. And that was repeated again in 2018. And the parties negotiated about extending that. And in fact, the Minnesota proceeding is about whether there was a third forbearance agreement as dictated by the ballots that were ultimately rejected by that court. So we've complied with the notice of claim statute. There is an interesting conflict in Arizona law about strict or substantial compliance. And as to the amount that a party will settle for, it is very clear you have to strictly comply with that amount. As to the facts, well, the Backus case from the Supreme Court says, we don't really want to be in the business of weighing whether there are sufficient facts alleged. As long as they set out the nature and basis of the claim, and the forbearance agreements clearly do that, no one can contend that there wasn't a sufficient statement of why the money was due and owing. So there is that intricacy of law. I think it is too easy to say, well, strict compliance is complied. The cases say to the contrary. And so I've got just one more point that I want to make, and that's about the Minnesota proceeding. Parkview went to Minnesota. Parkview solicited its bondholders and said, hey guys, give us this third forbearance agreement. And they got the votes of about 42% of the bondholders, but not 50% plus one, and that's what was required. So we went to Minnesota, where the trust is domiciled, and we asked a specialized Minnesota court to tell us, do we have to subscribe to what these guys say, or can we pursue our remedies under the loan agreement and the indenture and those documents? Parkview showed up, and they objected to jurisdiction, and they argued the merits. Their motion to dismiss, or their motion about jurisdiction over them, the court agreed that they didn't have personal jurisdiction, but the court then went ahead and ruled on the merits after a contested hearing. And to say that Parkview is not in privity with its bondholders who are representing a ballot that Parkview itself circulated? Excuse the incredulity in my voice about that, but that's just a step too far. And to not give credit, full faith and credit to a ruling of another court that's specialized for this purpose is, I think, too much. So with that, we would ask you to affirm the holdings of the Superior Court and to award us our costs and fees for having to participate in this appeal. If you have any other questions, I'm happy to answer them.
Thank you.
Thank you very much.
I've got a lightning round. You heard about waiver. Section 6 was read to you. That's the first time UMB has ever raised Section 6 in this litigation. Trial court now. I get a minute 10 to respond to it. This issue was not developed at the trial court at all. This is Havasupai. Havasupai was the same exact case. This court is bereft of any factual development, any Corbin attack on those alleged waiver provisions, and they took place in 2018. Arpaios' consideration of waiver starts when the notice of claim period has run. UMB didn't tell you the notice of claim period had run during those alleged waivers. And the issue is completely waived. It's a waiver of waiver argument. I understand it's kind of double, but that's exactly what happened here. This is a post hoc explanation that appellate counsel has come up with. It wasn't important at the trial court at all. Paragraph 73.
True?
What's that?
Is it true?
No, it is not true. That is not a waiver.
Don't say that.
I'm sorry, what's
The
that?
documents don't contain those waiver provisions.
The documents have those words in them. They do not waive notice of claim requirements at all, and they are not defenses to the underlying debt.
One last thought.
Paragraph 73, you didn't hear a word about its legal effect from the other side.
Did you write about it in your briefing?
Yes, we did.
Okay. And you argued it below
Yes,
because he said you didn't.
we did. We did. We said the amount due and owing is alleged in the complaint. The debt was accelerated. We argued the acceleration principle. We argued that the filing of the complaint accelerated. This issue is certainly preserved.
Okay. Thank you.
Clarify that in 2 seconds.
Sure. Quickly.
Very quickly. I did not say they didn't argue at the trial court whether a receivership was appropriate. They did not list that as an issue on appeal for this court.
Okay.
Thank you.
All right. Do you want to answer that? Because I looked through your briefing real quick because I don't remember that issue on appeal. Did you raise it in your briefing here?
May I seek clarification? What specifically you're asking me if we raised?
That the acceleration, that the paragraph in the complaint accelerated the debt, and therefore it changes our view of notice of claim?
Your Honor, we have raised that the complaint accelerates it specifically, and paragraph 73 is cited a number of times in both of our briefs. I read them this morning.
But did you make the argument that you made today
Yes. Yes.
in your briefing?
That the allegation that $9.1 million due and owing in a verified complaint accelerates the debt, yes. And the footnote that we cited was Adams v. Baer, the Arizona Supreme Court decision, saying, and they're stuck with it, Your Honor.
Okay. All right. Fair enough. Thank you, counsel, for your arguments. We'll take the matter under advisement and issue our decision in due course. At this point, the court is adjourned.